Hey, what's going on, everybody? It is Artie of Artie's Corporate Fiction. Glad to have you with us on Monday, May 1st. Happy to have you guys here. We have a very interesting subject to talk about today. This involves a St. Louis prosecutor, or for Missouri, circuit attorney. Kim Gardner. She was first elected into office in 2016, I believe, 2016 or 2017, in the wake of the Ferguson Ferguson riots. She came in as a reformer, progressive reformer, etc. But it seems like since then she's been the office has been mired by controversy. I'm not going to go fully into detail because we'd be here all day, to be perfectly honest. So I'm going to just rely on the immediate instances, which will, and some of the clips that I've chosen that we're going to take a look at will provide a little bit more background as to what's been happening ever since she was first in office. So going into the going into the here, this news story was 7 days ago, and I'll probably I'll give you more context as we if need be, but yeah, she's been around for about 7 years. 6 or 7 years now. 2 months ago, the circuit attorney's office got into another controversy where somebody who was facing charges of armed robbery had his trial delayed for another year because the prosecutors weren't ready. While that was going on, they, instead of him being held without bond, he was released with a GPS tracking and placed on house arrest. Apparently, he violated those terms 51 times. In other words, the GPS tracker on his ankle showed him outside of his house 51 times prior to him ultimately getting into a car crash that took the legs of a 17-year-old girl who was in town for a volleyball tournament. That resulted in the Attorney General for the state of Missouri 2 months ago moving for Kim Gardner to be removed from office in a via quo warranto. Sorry. But this is more than just that, though. That's just 2 months ago. Last year, she was reprimanded because another attorney, one of her subordinates, also did a no-show in a trial, which ultimately resulted in those charges getting dropped. There has also been issues with her financial disclosures. There's also been more than at least two former employees suing for racial discrimination against Kim Gardner's office, who are white employees who argue that the white employees who were there when she came into office were browbeaten or bullied out of into leaving the circuit attorney's office. That's their allegation there. So the office has been suffering from a very, very, very high turnover rate of circuit attorneys and prosecutors leaving, and of course, there's also the issue of her. About 3 years ago, we could watch that. We can watch this one. Either it was a year ago, 3 years ago, claiming that she was subjected to a targeted traffic stop by the St. Louis police on Christmas Eve. but where she claimed that they held her for over 15 minutes. She doesn't know why she was stopped in the first place, but local news captured surveillance footage of her getting stopped, where she obviously had her lights off, and the traffic stop itself took about just over 6 minutes. Anyway, it's a dumpster fire. That's the nicest way I could say it. It's a total dumpster fire that's going on in the office. We're gonna go to the second video, and then we're gonna go to the actual contempt hearing itself.
Thank you, Amelia. 30 past 8. Another judge threatening to hold St. Louis Circuit Attorney Kim Gardner in contempt of.
Oh yeah, by the way, this is the second order to show cause for contempt by Kim Gardner within like a week of each other. In the first order to show cause, the judge elected to not hold her in contempt, but I think on that same day of that hearing, another prosecutor another prosecutor no-showed at a murder trial. So that's why we're here again.
Court. It's the second time this week Gardner is facing a contempt of.
I'm Chris Renier.
No spoilers, guys. No spoilers. I do know of the more recent breaking news, but we'll get to that. But for now, let's go to the actual hearing itself. Come on. I thought I had this right. But there we go.
All right, you ready, Renee? All right, we're here on cause number 2122 CR 00600-01, State of Missouri versus Stephen Vincent. The court's going to take judicial notice of the entire file. Will the parties please introduce themselves, give us your employer, job title, and who you represent, starting with Mr. Ware.
This is Attorney Ellsworth Ware III, the law office of Ellsworth Ware III LLC. I am the attorney for the defendant, Stephen Linnell Vincent Jr.
Thank you, sir. Mr. Downey?
Yes, my name is Michael Downey. I'm an attorney at Downey Law Group, and I represent Ms. Gardner as he responded to the order to show cause.
All right. Mr. Huck?
Rob Huck, Assistant Circuit Attorney at the City of St. Louis Circuit Attorney's Office. I am not here in an advocacy role, but simply as a party designation on behalf of the CAO.
All right. Mr. Deslitz?
Judge Christopher Desilets, Assistant Circuit Attorney for cause number 2122 CR 00600.
All right. The court issued a notice and a show cause order on April 24th to Kim Gardner, Circuit Attorney, and her designated Assistant Circuit Attorney for indirect criminal contempt. Acts which constitute criminal contempt are set out in Section 476.01 RSMO. Subsection 3 is relevant for today's hearing. Every court of record shall have the power to punish, as for criminal contempt, persons guilty of willful disobedience of any process or order lawfully issued or made by it. In addition to the grounds set out in statute, other acts may be punished under the court's inherent power where such acts threaten the integrity, power, or dignity of the court. The question before the court is whether the actions of Kim Gardner and Chris Deslitz amount to disdain and disrespect for the court. The court will proceed with questions in order to make that finding.
Hello, Jester.
Mr. Downey, who do you represent?
Ms. Gardner, Your Honor.
All right. Do you represent her personally or the office?
I represent her personally.
All right. Where is your client?
She is not here today. She was asked to send either appear or come with a designated assistant secretary. Mr. Huck was the person she's designated.
All right. I do not see her present in the courtroom. Is she in the office, in the building? Do you know?
I do not know.
All right. When's the last?
So already we're off to a great start in that I will ignore you. We're off to a great start where she's not even showing up to her own order to show cause. So Yeah.
Last time you spoke to your client,
I believe yesterday.
was she aware of the hearing?
Yes.
All right. Is her designee present?
Yes, Your Honor.
That's Mr. Huck?
Yes, sir.
All right. Do you represent, Mr. Downey, do you represent Mr. Huck?
I do not.
Do you represent Mr. Desolitz?
I do not.
All right. Mr. Huck,
Yes, sir.
all right, where do you work? Stay seated. Where do you work?
City of St. Louis Circuit Attorney's Office, Your Honor.
All right, and who do you work for?
City of St. Louis, Your Honor.
All right, so is Miss Gardner your boss?
She is, Your Honor.
All right. Would it be fair to say she's the captain of the ship?
I would say that, Your Honor.
All right. And what is your current job title?
I'm an Assistant Circuit Attorney. I work as a General Felonies Team Leader for the General Felonies Trial Unit.
All right, how long have you been the team leader?
General Felonies, I would say since October of 2022, Your Honor.
All right. Does
You know, for an army judge, he likes to use a lot of maritime references. Curious.
Mr. Desolitz work for or report to you?
He does not, Your Honor.
Who does he work for or report to, if you know?
I don't think there's a team leader in Mr. Desolitz's unit. As far as, I believe he would report to the same people that I do, Your Honor.
Okay. So you're Mrs. Gardner's designee for today?
Yes, sir.
All right. When did you learn you were going to be her designee?
Within the last few days, Your Honor. I
Okay.
don't remember exactly.
All right. When's the last time you spoke to your boss?
Within the last few days.
All right. So she was aware of the hearing?
I believe so, Your Honor, of course.
All right. Did she give you any guidance or instruction as her designee?
Just that I was to be present, Your Honor. That's all I'm aware of.
All right. So what did you do to prepare for today?
So this is the guy that she's basically throwing to the lions, throwing to the wolves, whatever. Pick your reference.
Today's hearing.
I read
He's like, I'm just here so I won't get fined.
through the court's order in regards to this matter, as well as the order regarding media pertaining to this matter.
Okay. Do you know how many cases are assigned to you?
At the moment, I do not, Your Honor.
All right. The court was informed that you have 397 felonies and 301
Damn.
misdemeanors. Does that sound about right?
For me personally, Your Honor,
Yep.
I would take that to be correct.
So what? He alone is responsible for 397 felonies and 301 misdemeanors.
For me personally, Your Honor,
Ah.
I would take that to be correct. However, I would clarify to the court that many of those cases were issued under my name pursuant to procedure for when the office is issuing cases.
Okay.
And therefore that many of them were not intended to remain with me, but instead would be transferred to other ACAs.
All right, I understand. Do you know how many cases are assigned to Mr. Desolitz?
I do not, Your Honor.
Would you be surprised if I informed you that he has 104 felonies?
I would not, Your Honor.
All right. Do you know how many murder cases he has?
I do not, Your Honor.
Do you know how many violent crimes he has?
No, sir.
All right. Can you tell me anything about Mr. Desolitz's workload?
Beyond what you've just described to me, Your Honor, I cannot.
All right. So you're here as Ms. Gardner's designee, but you can't tell me anything about Mr. Desolitz.
That's correct.
All right. So when were you made aware of cause number 2122 CR 00600-1?
Within the last week, Your Honor.
All right. How were you made aware of it?
When I was informed that there was a show cause order in this matter.
All right. So is it fair to say prior to April 10th, you had zero knowledge of this case?
More or less, Your Honor.
Okay. So have you... hold on.
So going in completely blind.
Exhibits. Have you read the indictment? It's Exhibit C.
No, sir. Thank you.
Your Honor, if it doesn't matter, I have read the indictment.
Okay. All right. Mr. Hawk.
Yes, sir.
Have you read the probable cause statement, Exhibit H?
No, sir.
All right. All right. Are you aware that count one involves an 11-year-old victim?
He has no idea why he's even here.
All right. Are you aware if any of the alleged victims' family members are present today?
I am not aware, Your Honor.
All right. Have you heard from the alleged victims' family members?
I have not had personal contact with any of the alleged victims' family members, Your Honor.
All right. Are you aware if anyone from your office contacted the alleged victim family members?
I am not aware, Your Honor.
Yeah, basically, Aereo Scout.
Are you aware that the victims invoked their rights on June 25th, 2021, specifically stating, as a victim of crime, I request to be present and to be informed in a timely manner of court dates and continuances?
As per this document, yes, sir.
All right. But you don't know if that happened in this case?
I cannot speak to that, Your Honor. I do not know.
All right. You're not in charge of victim services, are you?
No, sir.
All right. Do you know who is?
I believe right now Malika Poindexter is managing Victim Services Unit.
All right. Are you personally aware of the alleged behavior of Mr. Deslitz regarding the jury trial on April 10th?
Only what I have read in Your Honor's order, as well as in speaking to Mr. Deslitz.
All right. So when were you made aware?
Only within the last few days, Your Honor.
Have you investigated the alleged behavior?
No, sir.
Have you talked to Assistant Attorney Doyle Losey?
I have not, Your Honor.
What actions were taken by your office regarding the alleged behavior?
I don't know, Your Honor.
Are you personally aware of the alleged behavior, Mr. Deslitz, regarding the status hearing on April 24th?
Only what was described to me, sir.
And is this the same thing a few days ago?
Yeah, within the last few days, Your Honor.
All right. Have you investigated that behavior,
I have
alleged
not.
behavior?
I have not, sir.
And so I'm guessing you haven't taken any actions regarding that alleged behavior as well?
That's correct.
Nope.
Your Honor.
All right. All right, Mr. Deslitz, I got some questions for you.
Sir.
All right. You entered on cause number 2122 CR 0060-1 on June 21st, correct? Here's Exhibit A, just to verify.
I believe so, Your Honor. Thank you.
Oh, Judge is definitely a Marvel fan.
To scoot further to the well because,
Around the corner? Sure.
yeah, Renee can't see you. All right, so you're the prosecutor of record, is that correct?
Correct, sir.
All right. And there's Exhibit B on the table. The victims invoked their rights on June 25th, is that correct?
It seems to be, Judge.
All right. And again, it says, as a victim of crime, I request to be present, to be informed in a timely manner of court dates and continuances.
It does, Your
All right. Was that done in this case? And if so, when?
Honor. I cannot speak with specificity as to when and which times. I know that I have met with the folks referred to on the forum. It's been a while now, in person and on the phone. But with specificity or about this particular hearing, I don't have any information about that.
All right. Exhibit C is on the table. Would you agree that it was filed on June 21st, 2021?
Yes, sir.
If you take a peek at it, that's your signature on that indictment.
It is, Your Honor.
All right. You presented this case to the grand jury, correct?
I did.
All right.
Okay.
I'm going to hand you Exhibit D.
So he's been in charge of this case from the beginning.
On October 17th, 2022, this case was set for a plea on Monday, October 25th at 9:30 a.m. in Division 22, correct?
Yes, sir.
That's your signature, correct?
It is.
All right. Do you know if the victims were notified for the plea hearing?
I can't say for sure about that date, Your Honor.
All right.
It's
Hand you Exhibit E. All right. On October 25th, 2022, this case was set for a jury trial on Monday, April 10th, 2023 at 9 a.m. in Division 22. Is that correct?
That's correct, Your Honor.
All right. Were the victims notified of that trial date?
Judge, I can't answer that. I expect that they were, if we had that much time for a trial notice, but I did not talk to them.
All right. And you knew you had to appear for jury trial in Division 22 on Monday, April 10th at 9 a.m., correct?
Yes.
All right. Where were you April 10th at 9 a.m.?
Judge, my approach,
You may.
I have prepared for the court.
all right. So right up to that point, the judge is basically calling him out and saying whether or not he has been adhering to his obligations for the victims and notifying them of what's going on with the trial and with regards to procedures and dates and times and so on and so forth. And he hasn't really been giving many solid answers. But here we go.
An affidavit. And I'll just refer to it, Judge, very loosely.
Can you give me 2 seconds?
Yes, sir.
I mean, I couldn't tell you what the standard caseload would be. I imagine it wouldn't be small for a large city, but I would say 104 is substantial for felonies, for heavy felonies. But I never worked as a criminal in criminal practice as a prosecutor, so I couldn't tell you what the average would be for a city like St. Louis.
All right, you may proceed.
Judge, in furtherance of what's in the affidavit, on the 10th, I was home trying to get medical treatment for a re-injured knee. Spoke with a colleague who was here, communicated that information, was told briefly that I needed to come back the 24th to reset. I arranged for treatment, came to work for part of that week, took additional time off. Tried a case in the meantime on Monday the 24th, showed up to Division 10 on the trial docket, dealt with that. At the same time, failed to email this division first to let them know I would be prioritized over there. Once I got a reminder from the clerk in Division 10 that Division 22 was ready, that's when I came over here. It was too late. Things were reset for Thursday. Here we are.
All right. So, again, where were you at 9 a.m.?
On
April 10th.
at home,
So where were you at 9:39 on April 10th?
same place.
All right.
At home.
Does Doyle Losi, is he assistant circuit attorney that works with you?
Mr. Doyle works in the Circuit Attorney's office. We are not assigned to the same unit.
Okay. All right. I'm going to hand you Exhibit G. And I want to draw your attention to line 12. Line 12 states, well, let me ask you, are you aware that on 9:40 a.m. that Assistant Attorney Doyle Losi stated on the record, Judge, I'm being told by Mr. Deslitz that he's currently on the way to the doctor's office, that he's had some kind of medical issue stemming from some type of knee injury that he's had, and so that he's not available today.
I see that's what the transcript says, Your Honor.
All right. You pause for a second. Mr. Huck, are you aware of any medical issues disclosed by Mr. Doyle?
Yeah, he did say he just testified that he was at home, but then he said that he was on his way to a doctor's appointment.
See in open court regarding Mr. Deslitz?
Only in reading the pleading, I believe, Your Honor.
Have you seen any documentation?
Oh, no, I have not.
All right. Have you verified any of the statements from Mr. Doyle gave?
In terms of verifying with Mr. Doyle, I have not spoken to Mr. Doyle, Your Honor.
All right.
I have spoken with Mr. Desolitz regarding the issue.
All right. So, Mr. Deslitz, how did you contact Mr. Doyle? Was it a text, voicemail? How did that message get passed on to the court?
I'm sure it was by phone. If it was voice or text, I don't recall. There were a couple of exchanges. I'm going to guess text. He was in court. So.
Okay. So did you and Mr. Doyle communicate about what was said to me or what my response was? I mean, did you follow up with him and say, did you pass that on? What did he say?
No, as stated previously, the response I received from my colleague was that I was to come in on the 24th to revisit and have my out-of-time motion filed and pick a new trial date.
Did he express any of my concerns regarding your medical issue?
Not that I recall.
All right. Did you check CaseNet to see if the case had been continued or dismissed, if anything had been filed?
Eventually, I did. I was from outside the court at 10-something, emailed the clerk, was told the new date. I didn't check CaseNet until someone delivered the court's order to me later in the day.
So I'm going to hand you Exhibit F. Did you see Exhibit F that was ordered on April 10th?
I did not. I saw a couple of other orders, but not that one, Judge.
So on the day of event in question, you didn't see what the court's order was regarding those events?
I saw several of the court's orders, not that one.
All right, I'm going to turn your attention to April 24th, which is on Exhibit F. Is that correct?
Yes.
All right. Where were you at 9:30 at April 24th?
All right. So he said he didn't even have any. Yeah, my understanding is that they never even he never provided any like proof of medical leave or no doctor's note, nothing. But
Judge Rex Burleson in Division 10 of the Civil Courts building of this circuit.
All right. So you're saying at 9:30 you went to Division 10?
yeah, those asking what's behind me, that is a gift from Doug, Dojak. It says drink Artie's beer and ale, and it's a light up sign. So yeah.
I was there before 9:30. Yes, at 9:30 I was in Division 10 on multiple matters with Judge Burleson.
All right. So is it fair to say that you made a conscious decision to go to Division 10 instead of Division 22?
Uh-huh.
I got there, Judge.
All right.
Yes.
So what time did you I saw in your affidavit that you said you came and the door was closed. What time was that?
Minutes after 10.
Ah!
Not sure how many.
Well,
Did you notify the court prior to 9:30 of your inability to attend?
As stated previously, Judge, I neglected to do that.
Okay.
you did
Now,
neglect
Mr.
to do that.
Deslitz, we've been working together for a long time.
We have.
All right. This isn't the first time you've been late to Division 22. Is that fair
Oh.
to say?
It's fair to say that every lawyer is late to a division every day, unless he's unemployed.
Why would you say that? Why would you say that? Hey man, we're all late, you know. Wow. Yeah. Man, imagine saying that in open court in front of a judge.
All right, I want you to say that again.
Say that again.
Is late to a division every day unless he's unemployed.
Would you like to qualify that? When you say every lawyer, are you referring to the entire Missouri bar, or are you referring? What can you narrow?
Yeah, are you putting every and look at his I paused at the perfect time of what the judge is asking. Oh, are you gonna throw every attorney under the bus? Or trying and say that every attorney is like you, who decides that they're going to show up late to court, or not even bother giving notice? Yeah, no. Speak for yourself.
Narrow that down.
Sure. It's just sort of a turn of phrase to
Oh.
acknowledge that every division in the circuit and in other circuits will set things at 9 o'clock, maybe 9:30.
Oh, no! Oh, no. Oh, God, no. Oh, he's gonna... I don't want to say it out loud because I'm going to get in trouble. But he's gonna... he's going to say he's got a... like, oh, it's at 9 o'clock, but you got a buffer? Oh, my God.
Some judges stagger. Almost everyone has more than one piece of business in a busy circuit. And so, with the inability to be two places at once, we are in one place on time and the rest were not. My foul here, I beg the court's pardon, is not that I was late, but that I failed to let you know ahead of time, and that's the problem.
Oh, God. Oh, my... Oh, my God.
So
it's fair to say, in the past, when you've been late, the court has been. It's fair to say we've made numerous accommodations in the past. Is that fair to say?
I would say, like every division, there are accommodations made every day for all of us practitioners, understanding we are in more than one place at a time, and this division makes those accommodations as well, yes.
Routinely.
Routinely.
So, can you tell me why you wouldn't have called and informed the court of the conflicts in this particular case? Do you have any justification for not doing so?
Justification, not sure. That's a strong word, and I'm not playing a game with you, Judge. I have an explanation.
The body language is so cavalier, I think is the best way of saying it. The body language is so cavalier. It doesn't feel like he understands the seriousness of the hearing.
I will say that since January of 2000, I've been appearing in divisions in the 22nd Circuit. Not every time when I'm going to be rolling into a division after the docket starts do I notify the division. Because as common practice has taught me, and the culture of this circuit, there is an element of understanding. And even a judge tapping his foot might display some patience as the docket goes on, knowing that lots of people have to be other places. So that even without an initial notification or a filing, sometimes I show up late like others. And the accommodation is so gracious that there's no trouble.
Oh my God. Oh my God. So is he actually saying, well, you know, with other judges, sometimes I don't even make them know ahead of time, but the judges, they know what's up. They know what's going on. So, there's no harm, no foul, right? That's what he's saying. He's saying that even in circumstances where he doesn't give the judge notice, he's like, other judges, it's all right. Oh my God. He's basically saying that other judges have been okay with them not being informed ahead of time because the judges know of the circumstances. It's such a terrible, terrible defense of this is so awful.
Right. In this case, I went to the docket that had, I guess, been prioritized as far as I can tell by the court. These were trial settings.
Oh, and now on top of this, he's saying, well, the other court business was more important than yours, Judge. Because the judge is not, because of course the judge is going to take that in stride.
So I went to the trial division first with the intention of taking a break to come over and to do the housekeeping docket and then go back to the trial division. So it's really not an unusual situation. It's like, I would say, every other Monday since January 2000 when I first started practicing down here. That day, like admittedly other days, I did not notify this division ahead of time before running late in the other division.
Did you even provide a substitute attorney who could handle the case?
Did I?
Yeah.
Did you? No. Of course not.
All right. Any further statements by Mr. Downey, Huck, or Desolates?
Judge, for purposes of satisfying the court's doubts, I have some copies of medical records.
I'd like to see them, please.
Do those in camera.
Yes, I will.
The issue is not so much about double booking cases. That can happen. I imagine that happens all the time in a heavy docket with overworked attorneys. That can happen. I'm not necessarily faulting that for a double booking. What I have the issue is him not notifying the judge ahead of time, and so that the judge can say, okay, we can hold off and wait until he's done with his business and then come back, or we can reschedule. Or two, acting so cavalier that he'll tell the judge, well, I don't want to put words in his mouth, but the way he acts, it's like, why are we making a federal case out of this? This happens all the time. That's basically what it sounds like to me. Y'all see the photo behind his chair?
All right, there's nothing else from the parties.
If it please the court, I have nothing further, Your Honor.
Mr. Downey?
Your Honor, you focused on the conduct of the office. You haven't asked much about Ms. Gardner. I'm happy to run through that for you. You asked Mr. Huck what investigation he had done. I'm certainly happy to tell you what work and investigation I've done, what knowledge Ms. Gardner had regarding this matter, if you'd like that to occur at this time.
No, I mean, I'd rather hear from Ms. Gardner's designee. The order was not for counsel to speak. It was for the designee or Ms. Gardner. So,
would I be scared? Not necessarily. I mean, it's not like the judge is, yelling. He's asking pointed questions. calm professional demeanor. I mean, I don't know why I would be afraid to be in front of this judge now.
But you also asked about the investigation of the matter.
I asked the designee about that.
Correct.
Right.
And obviously, since it was Ms. Gardner or her designee that should appear, Ms. Gardner asked me to do an investigation of the matter. I prepared a pleading on the matter.
I mean, I've received the response of Kim Gardner's order to show cause.
Yes.
Is there anything you want to supplement to that?
Your Honor, we believe that if Ms. Gardner is going to face potential criminal contempt,
Nervous, maybe,
for her to appear for that.
but certainly not
We also
scared.
believe that Ms. Gardner is entitled to discovery under Rule 3601 before such a proceeding occurs. That's set forth in the pleading. On top of that, we think the question here with regard to Ms. Gardner would be, does she have the requisite criminal intent? You have not asked questions of what information did she have prior to April 10th.
I did. I asked the designee all of that information, and the designee provided me answers, and the court's going to rely on the answers of Ms. Gardner's designee.
Sorry, call her out. So basically, what's happening is that what the judge is saying, I'm relying on the designee that Kim Gardner decided to bring in to fall on his sword. So I'm going to rely on his statements to glean potential intent by Miss Gardner. But the problem is that this attorney, I forget his name. I forgot his name. He was supposed to be representing Miss Gardner personally. So
I understood you asking Mr. Huck what knowledge he had. You didn't ask, for example, what knowledge the office had or what Ms. Gardner had. And I'm not sure the answer.
So I'm confused.
but she's not here.
What is Mr. Huck's role here?
Your Honor, you issued an order to show cause to Ms. Gardner or her designee.
Correct. And that's her designee, is he not?
Actually, there are two designated attorneys in the courtroom because Mr. Deslitz was the attorney designated to handle the case, and he would certainly be here. We wanted to make sure we had someone else here. Mr. Huck is here. But when you ask questions about it between April 24th and today, what sort of investigation has been done, that's primarily been my role, not Mr. Huck's role.
So when I asked for a designee, you sent somebody that didn't have the ability to stand in the shoes of Ms. Gardner? Is that what you're saying?
Your Honor,
Because Mr. Huck stated, and you stated, that he was her designee. So now you want to argue on her behalf.
no, Your Honor.
Yeah.
There wasn't a statement of I want the designee to come forward and state what investigation has been done. If you'd like to know what investigation is done, I'm happy to tell you. But when you asked for a designee, we had someone from the office on behalf of the office, but it wasn't, designate the person who's done the investigation between April 24th and today. I mean, Mr.
This is all her own fault. She instead of bringing herself in to answer for her actions, she brought in some poor sob who knows nothing of the order to show cause, who knows nothing of what transpired, to come here, and the judge asked him the questions, and obviously with little knowledge, he's not going to be able to provide any answers. So the judge is like, she's not here. You're her attorney. You don't have any personal knowledge. So what else am I going to rely on?
I think the role.
I'm confused.
Well,
Because it's pretty.
As you can see, the more you around, the more you're going to find out.
Pretty clear in the show cause order what the court wanted to know. Show cause. Miss Gardner sent Mr. Huck, not herself. Is that correct? Because she's not here. I don't see her in the courtroom. So the only person that's here is Mr. Huck. And Mr. Huck did his best to fill the shoes of Miss Gardner.
Okay. And what I'm trying to tell you is that when you issued your order on Monday, I was engaged to be involved in this. I had extensive communications with Mr. Deslitz.
Right.
Hey, Mike.
I mean, there was a question of who would take on the role, and the answer was I took on the role of investigating this matter.
I asked Mr. Huck if he investigated the matter. I didn't ask him who investigated the matter. I asked him if he did.
Correct. But But your order requesting a designee did not say, I want you to have the person appear to investigate this matter. I'm simply letting you know that the inquiry to this point has not gotten into all the information what the office has done. If you're in fact looking at what should happen to Ms. Gardner, which your order may be indicating, I'm saying, if you want to look at that, I think there's additional information that I'd be in the position to provide, that Mr. Huck's not in the position to provide.
Well, the court.
Yeah, but but again, the problem is you don't have any personal knowledge. You only have, I mean, you're effectively going to try and testify to hearsay. She's not here. I think that's the issue here. She's not here to provide her own personal testimony as to what the heck happened between April 10th and April 24th and today, or this date, which I believe was the 27th.
It's going to rely on the response of Kim Gardner.
Yes.
To order a show cause.
Correct.
All right. The court's going to rely on the designee, which is Mr. Huck, and the court's going to rely on the words of Mr. Deslitz.
Yep.
So the court's going to take a 10-minute recess.
All rise. Court is in recess.
And take a 10-minute recess. We're going to skip ahead.
Please be seated.
The only time I've seen her appear in front of a judge, Goddess, was with her a hearing from a year ago, where a committee gave her recommended a formal reprimand against her. It's the only time I ever actually, but no, it wasn't even in front of a judge. I forget it was like a 3-person panel. I can't remember the exact circumstances.
The Circuit Attorney, Kim Gardner, was served with a notice and order to show cause directing her or a designated Assistant Circuit Attorney to appear before this court on April 27, 2023 to show cause why she should not be held in contempt based on an alleged willful failure to appear in Division 22 on April 10th and April 24th. Ms. Gardner did not appear. Assistant Circuit Attorney Mr. Huck appeared on her behalf, and Assistant Attorney Mr. Chris Deslitz appeared. The question before the court is whether Ms. Gardner and Ms. Deslitz's failure to appear on April 10th and April 24th amount to disdain and disrespect for the court. The Circuit Attorney's office appears to be a rudderless ship of chaos.
Yep.
Ms. Gardner is the Circuit Attorney, and it is her duty to manage the caseload of each staff member. Mr. Deslitz has approximately 104 felony cases. Any prudent practitioner would expect such a caseload to create countless irreconcilable conflicts. It does not appear she has made any reasonable efforts to prevent the resulting chaos. It appears that Ms. Gardner has complete indifference and a conscious disregard for the judicial process.
Damn.
There is sufficient evidence of disdain and disrespect for the judicial process to determine that both Ms. Gardner and Mr. Deslitz's conduct support a finding of indirect criminal contempt. Furthermore, an attorney's violation of a court's order constitutes an intentional disobedience and shows a clear intent to disregard the power and authority of the judicial system process. If a court allows such disobedience to continue, then its orders will become ineffective, thereby undermining the judicial system. The court finds that there is the requisite conduct and intent which could support a finding of intentional disregard for the judicial process. Ms. Gardner has counsel. Mr. Deslitz has the right to retain counsel. Both will be afforded their due process rights to discovery and to prepare a defense. The procedure for indirect criminal contempt is governed by Rule 36.01b. Pursuant to that rule, this court will appoint a special prosecutor for this matter. The court will allow reasonable time for the preparation of defense. Accordingly, the court sets the matter for a hearing on Tuesday, May 30th, 2023 at 9:30 a.m. This concludes the matter on the record. We're in 10-minute recess to resume the rest of the docket.
All rise. Court is in recess.
Why indirect? Because it's failure to abide by a court order is usually indirect. Some jurisdictions differentiate as civil contempt versus criminal contempt. But I guess in Missouri, they have indirect criminal contempt and direct criminal contempt, where direct criminal contempt is something that somebody does in full view of the court, like, you know, punching somebody in open court, or disrespecting the judge in open court. That's direct. Indirect, I assume, would be failure to follow the rules or the procedure of the court. In this instance, failing to show up for court, or failing to abide by a court order, that kind of thing. That's my assumption. I don't know that for sure because obviously I'm not an attorney for Missouri, but that's where I would say they're distinguishing between direct and indirect criminal contempt. So, since then, as a matter of fact, this is breaking news today. See if I can throw it. This happened today, about 6 hours ago. Breaking news.
At noon, another St. Louis assistant circuit attorney has quit.
He's out. He's gone. He announced his resignation today. He's like, I'm out.
Chris Desolates is at the center of the latest contempt hearing. He resigned this morning, effective immediately. Thanks so much for being here. I'm Kay Quinn. The latest resignation leaves one prosecutor in Kim Gardner's office who is assigned to more than 400 violent felony cases. 5 on Your Side's Christine Byers broke the story this morning on KSDK.com. She's here with more on what this means.
Okay, so in February, Circuit Attorney Kim Gardner had 6 prosecutors assigned to her violent felonies unit, which even then some say wasn't enough. Each of them had more than about 100 cases assigned to them. Now, there's only one.
She had 6 attorneys on her violent felonies. On her violent felonies unit. And now there's one.
After Chris Desolates confirmed to me this morning that he is resigning. Thursday, then Assistant Circuit Attorney Chris Desolates was in front of Judge Michael Noble to explain why he missed a trial and a subsequent hearing on the same case. At that hearing, Noble noted Desolates had 104 felony cases assigned to him. The judge said a caseload like that makes it impossible for Desolates or any prosecutor to be in trial or at hearings without multiple scheduling conflicts. And Gardner has done nothing to do that to prevent that from happening. The judge then found enough evidence to move ahead with a contempt hearing for both Desolates and Kim Gardner. Now, since his resignation is effective immediately, it's unclear who will be handling all of his cases. And Gardner's office has not yet responded to our request for comment.
Okay, so what happens with this hearing? Because Chris Desolates was found in contempt last week. Does he still have to show?
Well, this is what makes it worse, Gary. The problem is not just simply settle at any cost. I mean, the defense attorneys, I feel like defense attorneys have all the leverage. They'll probably end up forcing the prosecutors to freaking dismiss the cases. due to due process grounds.
Show up to face those charges?
Yes. So essentially, his resignation does not affect the contempt hearing from going forward. He will still have to answer to Judge Noble, and we're also still waiting to hear who the special prosecutor is going to be on that case.
And what about the one remaining assistant circuit attorney? Is that person going to be able to survive and stay in their position?
The one assistant circuit attorney still left assigned to that unit is Sai Gurapati, and he experienced a medical emergency in court just a few months ago, and so he is back working, but he's definitely had some medical challenges as well.
So the one remaining guy, the one remaining attorney, had already experienced a medical emergency in open court. So I'm gonna throw out a guess, it's probably due to overwork. He's probably dealing with burnout already. And this poor guy, this poor person, whoever you are, my heart goes out to you. But what else is there? No, and that's the problem. And this is where I'm going to start actually getting pretty aggressive. Kim Gardner is trying her best to deflect any and all responsibility for this. And I'm calling, and she's from everything from, I'm out here to clean house, to blaming the forces that be that want to disrupt change. Lady, it's been 6 years. There's no excuse anymore. You have no excuse. Nobody wants to work with you. The turnover rate in the office is pretty atrocious, and it's been that way for the last 6 years.
All right. We know you'll have much more on this coming up on 4, 5, and 6 tonight. Christine Byers, thank you so much. Just hours ago, we learned.
And now the next news report from 2 hours ago. 2 more attorneys resigned.
About more departures from the office of St. Louis Circuit Attorney Kim Gardner. That means there's now just one prosecutor who's assigned to hundreds of violent felony cases. The most recent prosecutor to resign is at the center of a contempt case that could result in jail time, a fine, or both for him and Gardner. 5 on your side's Christine Byers was first to report on this most recent resignation earlier today. Christine, what new reaction do you have? You've been talking with judges today.
Exactly, Kay. So basically, other than legal filings, you rarely ever hear from a sitting judge, let alone all of them collectively from a single circuit. Today, they issued a statement expressing their concerns given all of the resignations. Assistant Circuit Attorney Chris Desolitz confirmed to me this morning that he is stepping down. He was just in court last week to explain why he missed a trial and a subsequent hearing on the same case. The judge noted Desolitz had 104 violent felony cases assigned to him and scheduled a contempt of hearing for Desolitz and Gardner for later this month. Also today, we obtained an email from Gardner, and she wrote confirming Alex Polta left her office last week. He also missed a recent murder trial. Both Desolitz and Polta blamed their absences on medical issues. In a statement today, the judges wrote, more recent departures from the circuit attorney's office, leaving fewer attorneys to prosecute hundreds of serious cases on the trial docket, are deeply concerning to the judges of the 22nd Judicial Circuit. At a rally over the weekend, Gardner addressed the staffing issue in her office.
Like I said.
Oh, that's the other thing she tried to claim, is that, oh, she hasn't been getting money. Bull. According to one of these local outlets, the budget for her office has been increasing in the last 3 or 4 years. I gotta double check. Like 3 or 4 years ago, it got a 35% bump, and then last year they got a 30% bump on top of that. So it's not so it doesn't sound like it's a budget issue that they can't find attorneys to circuit attorneys to work under her.
I don't care if I have nobody in my office.
because it's about doing the right things. And if you stand in silence and you sit there and watch the show and think it's okay, it's me here now today. It's going to be you next and your family next.
Now, Gardner's spokeswoman issued a statement just 2 hours ago, which read in part, while we have had some high-profile departures, the office continues to seek justice for the people of the city of St. Louis. The CAO has made adjustments to the workload to ensure all cases are covered and is actively recruiting talented attorneys.
So, Christine, what do we know about the prosecutor who remains in the violent felonies unit? There's just like one left, right?
Exactly. So his name is Sai Chiguropati, and earlier this year, he experienced a medical emergency in court, and it was his third medical emergency of the year.
So much pressure on these attorneys to do so much.
Exactly. I mean, they at least have about 100 cases per attorney.
That just seems like an impossible assignment. All right, thank you so much, Christine. Bye.
The public to know that we weren't set up to succeed. And that's exactly what the Attorney General said, because it's true.
Well, that's sound news since 6 o'clock, and part of the
That's another attorney who recently resigned.
big story tonight. Kim Gardner under fire in the Missouri Attorney General's effort to remove her
Hell
from
no,
power,
Whiskey.
making it to a St. Louis courtroom within the last hour. That hearing to decide if this quo warranto process should go to trial ended. There's so much to talk about, so much to understand with this as the city prosecutor stands accused of not doing her job. So News 4 Chief Investigator Lauren Traeger has been leading our coverage on all of this, and we're going to walk you through what has been playing out this afternoon in the courtroom. I think a lot of people going into this thought this hearing is going to be rather quick, but hours long, Lauren.
Yeah, about 4 hours here, a lot longer than we did anticipate, because they were going over largely a lot of procedural things as they were kind of trying to work out if this will in fact head to trial. But certainly a very historic day, I think one for the law school books here, because both sides arguing their points about what should come or go, whether this entire case should be tossed out. So there's going to be some precedents here. And we did, in the last hour, gather some more reaction from some of the parties here. In fact, a current employee, Reddit Hudson, who works for the Circuit Attorney's Office, also spoke with us. So let's take a listen to what he had to say.
She hasn't thrown anybody under the bus.
Really? This is 12 days ago. So this is 12. So this is about a week before the hearing that we watched.
She still stands behind her staff and the entire office in the face of these unfounded attacks. The Attorney General's action not only has the effect of interrupting and disrupting operations in the Circuit Attorney's Office, it has the intent of disrupting and interrupting operations at the office. Like me working to destroy the engine in your car and then telling you to drive it.
So let's get back into the courtroom, Lauren, and what exactly is being discussed, the arguments that we heard today from both sides.
Yeah, we hear this term quo warranto, and you think, what is that? It's a Latin term. It basically is saying that the Attorney General's office thinks she needs to be ousted from.
Well, that's the thing, Thomas. 2 months ago, the Attorney General has filed this quo warranto to get her removed.
They're trying to prove that there was willful neglect of her duties. The Circuit Attorney's Office, though, is, of course, the Circuit Attorney and her attorneys on her behalf arguing that's not true. And they are also saying that it wasn't necessarily her that had made some of these missteps or mistakes in the office, but that it was her subordinates or her employees. So that's why you hear that former employee speaking out saying we weren't given the support we needed, we didn't have the training, and that current employee who says, although he's not a practicing attorney, who says they are given what they need and that this is a politically motivated attack by the Missouri Attorney General against the will of the voters who voted Kim Gardner.
It doesn't make sense. Saying that this is a politically motivated attack doesn't make sense when the equally as progressive mayor of St. Louis, who is also another African American woman, is calling her out. and like Democratic members of the Missouri's legislature are calling her out. The politically motivated attack line falls flat when members of your own party are going against you.
into office. So it's certainly a lot of back and forth, but it really does come down to some legal maneuvering, if you will, with the Attorney General's office trying to argue that she did neglect her duties. And that's going to be the standard going forward. So what kind of happened today was the Circuit Attorney's office asking the judge just to toss it out altogether, saying they haven't met that legal standard. The Attorney General's office, though, saying we need to prove this in a trial. And it did appear from the questioning of the judge, as well as the fact that they set a September 25th trial date, this could be headed for what would be a very public trial then.
Kind of surprising afterwards, on the courthouse steps, a former employee who just left the Circuit Attorney's office spoke with the media. And what did she have to say?
Yeah, she did resign on Friday, and it was kind of a high-profile resignation. She called the workplace there toxic, said that it was untenable to work there, and she got kind of emotional. She's also being called to testify potentially and to provide documents that she has through a subpoena, and she said she wants to do that. She wants the public to see what it's really like to work there in the office. And again, she did get kind of emotional as she spoke today, but there were some protesters, some pro-Kim Gardner people behind her as well. So take a listen to what she had to say here.
Our interest is to make sure that the truth comes out and that the people and the families know what's going on. And my personal objective is for everyone to walk into this next election, should it happen, with more information than they had last time about what's going on in the Circuit Attorney's office.
Lauren, you did a good job explaining.
Basically, that former prosecutor is making is speaking to a press conference, and she was getting drowned out by sycophants.
What this case is all about. We actually do have some sound bites from the attorneys inside the courtroom, and want to play that for our viewers as well right now.
Might be getting that queued up.
The law of Missouri demands more. Just making conclusive.
This is a pretrial, I believe, a pretrial hearing on the AG's move to remove her from office.
Statements that Ms. Gardner willfully violated or neglected some duty is not enough. Missouri's fact plea to me, that might work in federal court, but that doesn't work in this court. This is an attack on the democratic process by someone who was never elected. And if Mr. Bailey doesn't like the job Ms. Gardner is doing, that's his right. That's his First Amendment, his right under Article 1 of the Missouri Constitution, and he can support a different candidate at the next election and hope the people of St. Louis agree with him.
The problem is, this isn't about a difference in opinion and a difference of strategy. The problem is that you're not getting anything done. It's not a matter of it's not about, like, you know, letting criminals out, allowing suspects go out on bail when maybe they shouldn't have. This is about you not actually. Thank you, Danny. This is about you not doing your job. You have attorneys that you're bleeding your office of attorneys, and they're not doing anything. That's the problem. It's not about sentencing differences. It's not about charging for whether or not you should charge for freaking traffic offenses or misdemeanors or what the hell ever. It's about her not prosecuting anything. We're talking about violent felonies not getting not going through court because your entire office is a complete dumpster fire. That's the problem.
The law of Missouri doesn't allow him to do what he's trying to do here and use this court to oust Ms. Gardner for stuff that he disagrees with, not on these allegations.
The circuit attorney's duties are hers, and they're not getting done. It's as simple as that. And the question is, does she know about that? And is there more that she can do? And we're going to prove that in several ways that are pled throughout the petition. These failures are public. They're known.
You know, Lauren, let's move all these legal proceedings aside. And there is something, you know, called workplace culture and just the practicality of being able to try cases in the city of St. Louis. And I think people here in St. Louis have that question is, even without these legal proceedings, from a logistics standpoint of having enough prosecutors to try cases, is that a reality with the St. Louis Circuit Attorney's Office?
Yeah, I think that's a great question. And we're not talking about just any kind of workplace culture. This
They have one, but at least in that hearing, I don't think they did. But I mean, her and her sycophants have all played the card several times.
Impacts every single one of us because it's about public safety. It's about criminal justice. You know, we're talking about the rights of victims as well as the rights of defendants here. And that has certainly been the big question. We have covered for years now some staffing shortages in the office and some mistakes and missteps that have happened. Even yesterday, I just reported on a judge who wants to hold the circuit attorney in contempt of court, threatening jail time or a fine because the prosecutor on that case never showed up on the day of a murder trial. So that was certainly brought up in court today as a big question. The judges, in fact, had their own attorney that came and said, we have some concerns about how public safety is going to be.
As a 2021, St. Louis's population is just under 300,000.
Administered and how criminal justice will be administered with all of this conversation ongoing. But the office, of course, has to continue to function on behalf of public safety. She is still the circuit attorney, and this trial is not set to start until the end of September, possibly even later. So I think we're going to see more of those questions coming up. Is the office operating? Is it effective? Certainly supporters of Kim Gardner say that it is, and the Attorney General's office is arguing that it is not.
You talked about the start of a trial date. Is that the next proceeding or next hearing as far as this case goes?
Certainly not. There's going to be a lot of conversations about what they call discovery in these types of cases, what documents will be produced, who's going to be brought forward for deposition. They are actually planning 2 standing status conferences on this case every single month. Wow. So you can count on News 4, of course, to continue covering it. There will be a lot more conversation to come on this. This is a long legal battle that is not near ending at this point.
And AG Andrew Bailey, he's in St. Louis to hold a press conference. Our Susan Elcori is there, still waiting for the AG's comments. So we'll bring that to you if we get that in this half hour, and of course on the KMOV News app. Lauren, really good reporting. We know you'll be on top of it. Thank you.
Thank you very much.
Yeah. So it's a complete, like I said, I want to say something else, but I want to not curse. But it's a complete dumpster fire over there. She's facing a lot, but the problem is, as of Sunday, where she spoke to her sycophants, she's completely defiant. Still says it's everybody else's fault. She's taking no accountability for how she's run her office for 6 years. Again, mind you, this is not like somebody who was just elected like a year ago, and she's facing all the powers that be. This is 6 years. And she's had issues with her office for the last 6 years, ever since she got in. So I'm very interested to see what happens on May 30th for this contempt hearing. And it's just nobody wins in any of this. You can look at and that's the funny thing. You can look at this from both angles. And nobody wins with how she's running her office. If you want to look at this from the lens of sympathy for defendants, right? Those defendants are getting denied their right to a speedy trial, because often what happens is when these cases are constantly delayed by prosecutors who are overworked and haven't been able to review the case at hand, that what they'll do is they'll dismiss the charges and refile them maybe in the same day to avoid a speedy trial dismissal, and which ultimately may end up leaving the suspect either in jail until the trial, or still subject to restrictions while they're out. On the other side, obviously, you're seeing victims. The victims are not getting any sense of justice. They're not being updated on the status of the case of the defendant. They're not, and potentially it's running the risk of suspects who may be, where there's really no doubt at all as to it, getting out, or the prosecutor's dismissing the case, or the judge dismissing the case because the prosecution is not charging, or excuse me, not moving forward with the case. So the victims are also denied justice. And furthermore, And the problem is, it's already happened. It's already happened where a year ago or a year and a half ago, the judge dismissed murder charges because the prosecutor never showed up. So nobody wins in a situation like this. Nobody. That's the problem. Anyway, I'm done. I went. I'm done with the rant. All right. But I'm very curious as to where this is going. I really hope they find her in contempt. I think the evidence is strong. I really feel like something needs to be done in St. Louis, because right now there's nothing else. There's nothing that could be done. If any criminal was smart and they understood just how bad the prosecutor's office is, what's there to stop them? They get arrested by the cops, right? They might get they get arrested by the cops. The cops move forward with the charges, but nobody's there to actually bring the charges in. It's out of the cops' hands. All they can do is arrest them and then release them. And then the judge is like, nobody wants to press charges, or there's nobody that's there to press the charges, so there's nothing that can be done, and they're off to do whatever the hell they want. If I was a criminal, St. Louis is the place to be, because there's nobody that's going to be there to prosecute the case. I mean, that's how bad it is. All right. I want to thank you guys for hanging out with me tonight. I appreciate you enduring my rants. But thank you. Please hit that like button on your way out. And I will see you guys on Wednesday. I'm sure there can be I'll have some more videos lined up for us. Heather, yeah, I just went to Google, I guess the actual metropolitan, or not the metropolitan, the actual city limits. I know the greater like metropolitan area for like St. Louis and Kansas City is like 2.8 million, but the actual St. Louis itself, but you're right, St. Louis County, which I think is her jurisdiction, is like 2.3, is 997,000. Thank you. I can't do that, Goddess. I apologize. I don't know if I can really answer those questions. I kind of want to be more specific to her current circumstances, rather than the underlying murder case that kind of spurred this whole thing. So I can't really speak to that. But I want to thank you guys. What do you want, boy? The boys are here. They probably can tell that I'm about to log off. All right, guys. You have a good night. Thank you. And I hope you have a good rest of your evening. And I'll see you next time. All right? Adios. Bye, guys.